Good evening, Deepak, Jijendran, Nisha, welcome. All of you, good evening. How are you, Bharath, sir?
Doing good, sir. How are you, sir?
Superb.
Happy evening, Deepak. Nisha.
Namaste. Good.
Maila madam. Okay. Good. Pooja madam. Oh, many people. Okay.
Aditya, Keshav, Saffron. What happened? You are not attending tax class? Pavitra, GST class you are missing. Welcome, Pavitra. Harihara, Hari Krishna, Geetika, welcome. Mangalore, Ashwini, welcome. Varun, how are you, Gana? I think Varun is the first person finished all test series.
Oh, very good, sir.
8 subjects, 5 papers, all over it seems. Good, Kanna. Keep it up. Shiva, welcome. Jasmine, good evening. Yeah. Okay.
Harini, happy evening.
Okay. Very good evening to all of you. Welcome to Premier Academy's webinar series, Last Minute Revision Strategy. Today's session is about CA Intermediate as well as IPCC law paper, how to approach law paper, the way in which you have to present the paper, the expected questions for areas for the coming examination, and how we have to remember the techniques, how to manage in the exam hall. All those techniques is going to deliver by our Bharath Kumar, our faculty. Welcome, Bharath Kumar.
Thank you, sir.
Over to you. You can start.
Thank you. Thank you, sir. So, guys, this session is going to be very vital. It will start from now and it will end up by 5:45. A period of 45 minutes, I'm going to cover up all the questions that are going to be expected. So we always say this, whenever you have something in mutual funds, they'll say, insurance is the subject matter of solicitation. Read the offer document carefully before investing. So I'm just changing the words now. So the words that I wanted to change is, expected question is subject matter of the intuition that is from the faculty. Read the study material carefully before going to the examinations. So this wordings that I wanted to change, because many people think that whatever is expected question is going to be there in the question paper. It will be there, but it is based on the intuition and the experience that the faculties have got. So we wanted to do accordingly. Okay, coming to the concept of how to start with law. The moment you complete with your accounts paper, you need to know from where you will have to start your law paper. Let's take for an example. You would have prepared a list. What and all you should have prepared by now, I will tell you, so you can accordingly remember all that. Number one, the number games, where and all the deadlines that you try to have for your law, all this has to be remembered. Number one, you should have already prepared a list. Second, the resolutions list, whether it is board resolution or ordinary resolution or special resolution. That's again going to be important. Whenever you have a authorities involved, whether it can be central government, whether it can be NCLT, National Company Law Tribunal, who is the final fact-finding authority, or it can be ROC, or it can be regional director, or when it comes to your listed companies, SEBI, Stock Exchange Board of Securities Exchange Board of India, relating to the stock exchanges, where you will cover. Apart from this, what and all is there apart from Companies Act, SEBI, when it will come, SCRA, for example, the definition of securities, Securities Contract Regulation Act 1956, that has to be getting covered. Dematerialization, rematerialization, Depositories Act 1996, that list has to be prepared. And when it comes to your prospectus and allotment of securities for both the syllabus, What's more important is to know what is civil liability and what is criminal liability. The moment when you come to criminal liability, you should have told what is the section 447, which is punishment for fraud. Like that, you should have divided that. So the number one is number games, the deadlines that you will have to prepare. Anyways, we will cover all that also. Number two is going to be so important, which is your authorities. Number three is your resolutions, and all these things are so very important. So the important or the expected questions which we have already shared, we can again share. And apart from that, whatever is going to be important for the syllabus, we have already prepared the list, and we will show you that list also, and it is going to be easy for you. So we can provide that. So these are the basic things that you need to cover for subject called law. So when you start, it is hardly a one-day gap that you have got between your accounts and costing in FM. So the major categories, you can divide law into three. Number one, MCQs. For MCQs, we will take a separate session, and it will be announced soon. Now the second is question and answer. The third is case-based question. So if you divide that 100 marks, you can divide that into very easily these three. MCQ we will cover separately. Question and answer and your case-based questions we can accordingly cover. So let's go one after another and try to see what is there for your case-based questions. So number one is your small company. Small company, section 2, subsection 85. So we can accordingly remember that paid up capital and turnover limits, they are definitely going to ask you, because there has been a change in that numbers. Paid up capital and turnover, usually it will be or conditions. Any one if you satisfy also it is enough, but it is not like that for small company. You need to consider it is again a part of your private company, and it is not public company, but paid up capital and turnover limit. So they have asked this question n number of times, so we can accordingly try to remember that. So that's the number one. Second, conversion of one person company into another company. When you can convert from one person company and when you can move it to other company. Can you do that against section 8 company, or one person company can be converted only into a private or public company? That question again, it is very important, so please note it down. The third important question is the entrenchment provisions. What is this entrenchment provision? It will get covered in articles of association. So you can accordingly remember that articles of association, you will always say either it is for private company, all the members should be okay with the resolution. If it is going to be a public company, it will be for special resolution. Entrenchment is a protective clause that you will have in articles of association. So you should always connect that with entrenchment and alteration, which is your section 14. So what I am covering here is the RTP, which I have marked it in a brown color, is going to be RTP May 2020 exams. So I am connecting the RTP questions. The RTP which I have marked in the yellow color is going to be RTP November 20 exams. So we need to be careful about it. Next, section 2, subsection 40, financial statements. Many people do not even know that the financial statements has to be in order. Balance sheet as at the end of the financial year. Like that only you should complete. Second, profit and loss account. Don't stop with profit and loss account. If it's a non-profit organization, you will have to cover your income and expenditure. You will have to prepare an income and expenditure account. Third, cash flow statement. So cash flow statement, the third important point is which company need not prepare the cash flow statements. Like that they are asking one question. So you should know whether the section 8 company, small company, dormant company, all these things, whether to be preparing cash flow statement or not. Very important in the third point. They are not going to ask you list down the financial statements. In the inter level, they will not ask you that. The most important thing from the ICA's angle is what you should think. When there is a provision, always we will say law is always two sides of the coin. When you say one provision is there, the other provision they will say exceptions or non-applicability. What and all is going to be covered will not be majorly asked in the exam. What and all is not covered in that only they will ask majorly in the examinations. Like for an example, which company need not prepare the cash flow statements? That they will ask you in section 2, subsection 40. So I have told you section 2 subsection 40, the third. Fourth is statement of changes in equity if applicable only. The fifth is explanatory notes forming part of the clause 1 to 4 or A to B. So you can accordingly try to remember that. So the third point, cash flow statement, chances of asking is more. What I have found out is from the 6 or 7 suggested answers, how they are asking up the questions and how it is applicable for November 20 is what we have prepared. That's the most important thing. So the next thing is prohibitions of NPO. What is this prohibitions of NPO? What and all the Section 8 company should not do. It should not declare dividend, and it should use only profit for the objects of the company. Usually people say, sir, profit and all will not be there for Section 8 company. It is not like that. Profit will be there, but the profit should be used and applied only for promoting the objects of the company. So what are those prohibitions? They will ask you. So please try to remember that. Next, guys, there is in incorporation of the company. This and all is for both old and new syllabus. So I'll cover, so it's easy to manage. Number one, whenever I wanted to talk about incorporation of the company, the forms they will try to ask INC 32, INC 33, INC 34. INC 32 is SPICE, simplified pro forma for incorporating the company electronically. So I'll again repeat, SPICE is simplified pro forma for incorporating the company electronically. Now SPICE plus and all has also come. When you wanted to incorporate company, these three forms you will have to remember. INC 32 is your SPICE. INC 33 is going to be your EMOA. INC 34 is going to be EAOA. So accordingly, you can try to remember. Yes, Nishita also told the exact same thing. So if at all, when there is going to be any prohibition on the non-profit organization, you can accordingly try to remember this also. Now coming to section 7, which is your incorporation of the company. Usually they will ask one question, when and all, if the incorporation of the company provisions is not applied, NCLT will come and try to do 5 things. They have already asked this in the previous examination. So section 7, reduce it only for your MCQs, not for your case-based question. I am telling you what is to be remembered, what is not to be studied also. Not to be studied means I am not asking you to omit and go. I am asking you to give less priority. We always have A, B, C category, right? So the A category is what I have listed. Next, revocation of license by central government. There is a beautiful chart that is given in the latest study material. Please go and check that. From there, they are asking the case-based question, whether they can wind up or whether they wanted to amalgamate with any other Section 8 company, or if there is any contravention of the provisions. The central government has got always the power to convert that into a private company or public company, correct? Always winding up is not the solution whenever there is non-compliance of provision. So when there is a revocation of license, when they are not promoting it for the objects of the company, so what they will do, automatically they can try to do any of these things. How they will revocate the license by central government in Section 8 company. So I have marked the section numbers here. So if you see, this is your section numbers that I wanted to cover. So revocation of license by central government, again very important. Now, the 2 major documents. What are the 2 major documents we have? Number 1, MOA. Number 2, AOA. In MOA, tables, they will ask in MCQ. I will cover that in the another session when we cover MCQs. Here, what is important? Name clause or situation clause. They are going to definitely ask it. Situation clause is otherwise called domicile clause, the registered office of the company. When it is within the city, what you should do. When it is within the state, or from one state to another state, or from one state to another state, or within one ROC to another ROC. There are 4 limbs that you have got. They are asking the 3rd limb, ROC to one ROC to another ROC. What is that you should do? You should get the permission of regional director. They are asking that question. So let's be really, really strong in that. That is your name clause or situation clause. Name clause, you will have definitely the important thing which I have already marked here. See the section number 13. This I'm expecting this time because it's going to be so vital. What is this? When will you alter the object clause of MOA? And that is section 13. They also connected with section 16. Then there is going to be a name change. Within how many months you will have to do? when there is a trademark that you wanted to apply and you have already been incorporated 3 years before, and when you will have to change it. If at all for the trademark that you wanted to, that's the 6 months limit. And when there is a name change, there is a 3 months limit. And all those things has to be informed to the registrar within a particular period of time. I'm expecting this question really strong. So whenever you read the question, please concentrate for, ask for what type of question it is. First to see whether it is a private company or one-person company or small company or public company or listed company. I'll again repeat, first see whether it is one-person company or private or public or section 8 or going to be your listed company or public company. When you wanted to see, half of your problems get over. Second, check whether this and all I am talking about for incorporation of the company. Check whether name is changed or situation is changed or object is changed or capital is changed. Like that you can see, because this is the 5 clauses that you try to have for your memorandum of association. That is the next one. Next most important question again, which I am expecting for this time, is subsidiary company not to hold shares in the holding company. So section 19. For that you should know section 2 subsection 87, which is subsidiary company. Connect that subsidiary company with section 19. So what I am writing here, I am writing section 2 subsection 87 also. So read both these things to cover, and usually we will always have paid up capital limits. Now and all it has become the voting power. So you should be very careful about section 19. 2-3 type of questions that they can ask. What and all is the prohibitions for say section 19, non-applicability of section 19, and what are the other factors that you should consider for your section 19. So these are the 2 important questions that they are asking. Now what I have marked in this yellow color is all based on your incorporation of the company. Guys, can you now tell me what is there in section 20, 21 and 22? I have marked this. I am going to mark this in yellow color. Can you tell me what I have written here? One concept is sure, and I have written SAE. I have written. What is this SAE? Can you guys tell me? What is SAE? Because from that one question is going to be for sure. What is this SAE? Can you try? Section 20, section 21, section 22. If you have studied this, we would have used that as a mnemonics. That's the shortcut technique. So you can accordingly try to remember. The service of documents. Very good. Yes is service of documents. Very good. A. What is A? Authentication. Very good. Authentication by KMP. So you will connect that with section 2 subsection 51. Very good. That is also done. What is E? I will itself tell you. Let me see if somebody is answering. Otherwise, I will tell. No issues. Yes, the third one is authentication of documents, and the third one is execution of bills. So this time, service of documents, they have asked this in RTP question. That means it can be by the documents can be served by way of a post or a registered post or a speed post or courier or any other mode authorized, electronic mode also. Correct. Many people are answering. Fantastic. Execution of bills. So in that, the service of document, they will ask this question because it's an RTP question. 2-3 times they have asked in RTP. This RTP, which I'm marking in the yellow color, is November 2020 RTP. That's the connection I wanted to give with the expected question on RTP. Now with this, incorporation of the company is over. Next, securities to be dealt in stock exchange, the payment of commission. Please try to remember this. Payment of commission, very important for examination. Again, maximum question that they have asked in the 3rd chapter is only this. So I wanted to mark this again in yellow color. So please take that really strong. Payment of commission. For shares, how much percentage? For debentures, how much percentage? You will have to compare with the articles of association. So for shares, it is 5%. And for debentures, it is 2.5%. Whichever is lower has to be considered. They are asking this question again and again and again. So this is one important question which they will ask it from the securities to be dealt in stock exchange. I already told you, the moment when you use a word called securities, you should get covered with Securities Contract Regulation Act. That's again very important. Yes, 2.5% of debentures. Yes, 5% for shares. Good, Pavitra. This is what they wanted to compare it here. They will ask you this case law question. Please write it and keep it. Next, private placement, section 42. You have act, you have rules. When you wanted to say act, they will say the private placement should not be given to, it should not exceed more than 50%. When they wanted to say rule, they will say 200. What is this 50 and 200 is what they will ask you in the case law. The beauty you will have to remember is this 50 or this 200 will exclude two things. See the point there: qualified institutional buyers and the employees that is given under employee stock option plan. So these two will be excluded, and this is for each kind of security. Every kind of security, this 50-50 limit has to be changed. So consolidatively for each security you can go till 200. So they will try to ask this question. So like example 55 they have given, 4 QIBs are there, so you exclude. 51 is coming, you should not write the conclusion saying it has exceeded 50 for private placement. No, that's per the act. But as per the rules, 200 is there. So still 149 is possible. 51 only is covered because it is for every kind of security. Like that, they will ask you questions. So let's be careful about it. Next, in the same private placement, whenever you deal with the non-compliance of provisions, that private placement will become public offer. When it becomes public offer, automatically SEBI regulations also will come into picture. When you go for initial public offer, automatically they will convert because you have non-complied with the provision. So you will go to the public offer. Next, types of prospectus. You have 4 types of prospectus. Yes, what are the 4 types of prospectus? 3 actually. We tell it as 4. We call it as SARO: shelf prospectus, abridged red herring prospectus, and your deemed prospectus, which is called offer for sale of securities. In that shelf or abridged prospectus, they can ask you. Shelf prospectus 3 times they have asked. So chance of asking shelf prospectus and information memorandum. That is the next one. Yes, the next point you will have to remember is debentures. Debentures amendment is there for debenture redemption reserve. You should not bother about banking company. Don't bother about all India financial institutions. This is November 2020 amendment. Don't bother about banking company because nil. Don't bother about your all India financial institutions like NABARD, Exim Bank, SIDCO and all. Don't bother about your other listed company. When it comes to listed companies and other companies, that alone has to be covered. So you need to bother about how much is going to be a debenture redemption reserve, how much is going to be a debenture redemption fund. So they would have already told. For the other companies, it is unlisted companies, it is only 10%. So from 25 it has come to 10%. So that again it's very, very important. So that's your one of the question. Either the issue of shares at premium or prohibition on issue of shares at discount or sweat equity shares. One question can come. In premium, they will ask about securities premium account application. So remember that. When you cover share capital and debentures, when you cover the flow, 53, 50, 52, 53 and 54 is your premium discount and sweat equity shares. 56 to 59 is your transfer and transmission. In that 58 alone, they are asking in case law question. So the deadlines is for private company separately and public company. If the company is not registering the securities, what will the transferor company do, or what will the transferee company do? One case law is for sure. Next, alteration of share capital. Easy 5 points as per section 61. Whether you can increase, subdivide, consolidate, cancel, or you can try to subordinate. So there are 5 things you can try to remember. So cancel also you can do. You should not compare that with reduction of share capital because 61 will not go with the 66. So that again you should try to remember. Bonus issue, this time it is going to be sure. So I am marking it because last time they have asked the rights issue, this time bonus issue. RTP November 20 question. Please read it. Next, section 61, section 67. Whenever we wanted to talk about buyback, it will cover from 68 to 70. But before that, we will say restriction by the company to purchase its own shares except buyback. So that 67, what are the restrictions that you will try to have? They are asking this in RTP and RTP May 2020 they have asked. So with this, we are completing the share capital and debentures. Now next, coming back to the acceptance of deposits chapter. What is for public, what is for private, how much should not exceed 35%. Private means it should not exceed 100% of paid up capital or your paid up capital plus free reserves plus securities premium. They will ask this question in case law. I have seen 2-3 times this question. This time also it is going to come. So chances of asking that is there. Definition of eligible company for a public company. So that public company limit 100 crores, 300 crores, 500 crores, that limit you always have, you will get a confusion. So please read definition of eligible company. Minimum and maximum period of deposits, 6 months not exceeding 36 months. So they will ask this in the case based question. So remember that also. For the charges, if you see, there is a beautiful chart given in the study material. What is before 2/11/2018, what is after 2/11/2018, when you wanted to create a charge and register the charges, within what time you can try to do. Very important question for MCQ, so take it really strong. Next, registration of charges. Within how many days once you create a charge you will have to register. What in the time limit only I have connected with 2/11/2018. So you should remember this really strong, this dates. Old syllabus people also be strong. You should ensure whatever is amended as per November 20 only has to be considered for you also. So please take this. This is applicable for both old and new syllabus. The net worth more than 100 crores. Yes. So that's again a very important point. Correct. So what Arvind is asking, exam will happen on time. I assume that the exam is happening on time, because if you think that you are going to procrastinate, nobody knows about it. So ensure that it is already in time and it will happen in time. Only then you can finish your preparation and start studying, writing your test series. That's very important. Next, what is your power of central government? What is the power of ROC in case of charges? Every people consider only satisfaction of charge or charge creation or charge registration. Nobody is studying what are the powers of ROC if at all the charge is satisfied. Company also need not tell. Charge holder also need not tell. But the power of ROC can give. It is the power of ROC to give memorandum of satisfaction of charge. So you can do. Central government can also do when it is think it is going to be for a public interest. So powers, please study carefully. Next, coming to the management and administration. Usually we will say 21 clear days notice, but in RTP they have asked this time for November 20, 90 days only, 19 days only is coming, because on the day on which you wanted to send, on the day of the meeting will be excluded. So 21 clear days. But if you calculate and see as per the RTP question, it will only be 19 clear days. Is the company non-complying with the provisions? They will say as per the company said, they have not told openly that it should be 21 days. It can also be less than 21 days. So the contention of the company is tenable only. It will still manage with the annual general meeting is what they would have completed. So please take this really strong RTP question. You thought notice, it will be very simple. Guys, notice, you should always see whether it is ordinary notice or special notice. When it is special notice from members, it will give to the company. From general notice from company, it will go to the members. 21 days versus 14 days. Always try to remember that general notice and special notice you should compare. Next, AGM. What is the first AGM? Within how many months they should complete? They are asking this question. Though it is from the audit and auditors, which is not applicable for old syllabus, they are connecting, but they are still asking it connecting through your meetings. So you should know what is before the meeting, what is during the meeting, what is after the meeting. So again, I will repeat, before the meeting, they have already tested last time. That means explanatory working statement and notice. they have indirectly tested, but this 19 days notice alone is there in RTP. During the meeting is QCPVR. I'll tell you what is QCPVR: quorum, chairman, proxy, voting, and resolutions. Proxy, n number of questions are coming, so we need to see whether it is private company or public company. And quorum, again, that you will have to see that 48 hours limit that they are asking. See the next point, RTP, this AGM and quorum, they have asked in RTP May 2020. So go and study with that case law. What I am going to cover only will be there again. Special notice, I have already told you, it is based on what? It is based on your 5 lakh worth of share. It is based on 1%. They are asking as per section 115. So what I am going to write? I am writing it here 1% and 5 lakh worth of shares. So that you wanted to cover. So this they are trying to ask you worth of shares. They will ask you who can try to go for a special notice when they wanted to give it to the company. That voting power 1% and the voting power and the 5 lakh worth of shares. Next, president and governor are going to be the members of the company. If the president and governor is not coming, who will come and attend the meeting? What are their powers? If you see the powers, you will understand. For the president and governor, there will be representative. Many people are writing legal representative. That's a wrong word. Representative is the correct word. So how you can manage it for president, how you can manage it for governor of the state and president of India, how you are going to manage, that's very important. Next, after the meeting, see, if you see what will be there in MOM is after the meeting. What is this MOM? So after the meeting is MOM is minutes of the meeting. Now chairman's discretion, whether it has to be covered in minutes of meeting or not. What is the discretion? Chairman's discretion. What and all he will avoid in the minutes of the meeting? They are asking this question. So be strong and careful about it. Now coming to exclusively new syllabus. Interim dividend declaration. I have a loss in a particular year. Should I take an average of 3 preceding financial years? Yes. So that's an RTP question. Very important for this November 20. Payment of dividend has to be made only to registered shareholder or to the order or to the banker. Let's take for an example. Before the AGM, I wanted to transfer shares from myself to another person and he registered the shares within the annual general meeting. Can he be paid dividend? Yes, because he is been a registered shareholder. Like that, there is a case law question asked. So be careful. Who shall file the financial statements? Connect that with your KMP. Section 2, subsection 51, and you can connect that with who shall file the financial statements, RTP May 2020 question. The most important question for you for the new syllabus for the November 20, exemptions from punishment from payment of dividend, from dividend payment. There are 5 exceptions are there. The second and fourth, they are again and again asking in dividend. They will not ask you deadlines in the case law. They will ask that in MCQ. Exemptions from punishment of dividend, section 127. Please mark it important. There will be 5 points. All the 5 are very important. Definitely one question is going to be there. Next, accounts of companies, National Financial Reporting Authority, NFRA, amendment is there. So amendments, chances of asking is there. What is the period? What about auditor? What about the registered valuation under section 247? Amendment question for sure they can ask you. In section 134, board report. So what is this contents of DRS? It is all based on your board report. So the point is, you should understand in section 134, DRS separately they will ask you. What is DRS? Director's responsibility statement. Definitely they will ask you this one question. There will be some 5-6 points for DRS. They are asking this. Next, CSR activities amendment. So CSR activities, I'll color it in a different color. So you will understand it is an amendment. CSR schedule 7, 3 amendments have been made. So you can try to cover that from your RTP question. Schedule 7. Usually we will say, if you are not able to remember the section number, remember the chapter number or remember the schedule number. CSR is schedule 7. So you should connect what and all activities will be based on your schedule 7. So that's again very important. CSR committee limit. For you to have a CSR committee, minimum 3 years, you should maintain that limit. What is that limit? Net profit or turnover or what is that you wanted to do? That 3 limits are there. Either or condition, they are asking this in MCQ. 137 AOC 4, filing of the financial statement in XBRL. What is the limit? AOC 4 XBRL, the form number also they will ask you. So let's be strong about that. Previously, if you see in audit and auditors, disqualification of auditor will be asked again and again. They have already asked that in November 19. I'll again repeat. Disqualification of auditor, there will be some 6 points. In that, the disqualification, 1 point. What is that? 143 section 143.3, they will ask you again and again based on that security, 1 lakh security. So they have already asked that in November 19. Give that a less priority. Concentrate on 2 questions. Tenure of auditor and audit firm, 5 years, 10 years, and cooling period of 5 years. You should remember. Prohibited services. There are some 10 services which is prohibited under section 147. What are they? They will ask you, can the auditor do this? Implementation of information system, actuarial services, what he can do, what he cannot do, they will ask you 1 question. So be strong about that. That's again very important. This and all is for your company law. Next, coming to your other laws for both the old and new syllabus. Finder of lost goods. They will definitely ask you this whenever they wanted to cover your Indian Contract Act. So what I'm doing here, I'm saying what is this act, so you can accordingly remember that also. Indian Contract Act. Preamble, very important question for the new syllabus, which is from your interpretation of statute. Revocation of continuing guarantee. Please write this and keep. Again, it is from Indian Contract Act. Modes of creation of agency. I am marking this question, very important. I'll put it in yellow also. What is this? Whenever you have an agency relationship, there is one example where the wife and husband is separated. On behalf of the husband, wife goes to a saree shop and she wants to get something on credit. Now, whether it is necessaries or not necessaries, whether agency will be created or not, whether the silk saree shop will be able to take the amount from husband or it will take from wife, they are asking 1 question. Very important question. It is there in your suggested answers. That question definitely they will ask you. So Indian Contract Act. In negotiable instruments, there are only some 3-4 points that they are asking. First is what is holder and holder in due course. Already who is holder they asked last time. Essentials or privileges of holder in due course. Please mark it important. More important for your exam this time is noting protest and protest for better security. The notary public with a certificate they wanted to give. And section 44. Again, this question also is very important. Till now, they have asked 5 times in the examination on negotiable instrument without consideration. So I will write here 5 times they have asked this question. They have asked 3 times in the examination and they have asked almost 4 times in this exam. All these are repeated questions. Again, this is from Negotiable Instruments Act. Sans recourse versus sans phrase. This is your endorsement, types of endorsement for both old and new. So I will say O and N. For both old and new, they are asking this endorsement. So remember carefully. Computation of time is going to be so important from General Clauses Act. A particular date is not mentioned. When it will be starting from, they will ask in general clause. Whenever the president assent, from there it is implemented. That's the date. They have asked this in General Clauses Act. Document. What is the definition as per Indian evidence? General Clauses Act. Mandatory versus directory. What is that they will ask you? They will ask you may versus shall. What is may? What is shall? Listen carefully. Shall is always mandatory. May is always directory. That's the only one side of the coin. The other side of the coin is when and all may will become mandatory. When and all shall will become directory. They will ask this question in interpretation of statute. Again, very important. Mischief rule or Hayden's rule. Many times they have asked interpretation of statute. There are 6 constructions. One of the most important construction is mischief or Hayden's rule. IOS, again interpretation of statute. Proviso definition they are asking. Now coming to the new syllabus. Now completed with the old syllabus, new syllabus. Let's come to the old syllabus. Gratuity. What they will ask? Calculation of gratuity they are asking. So what and all salary, wages you will have to calculate. What is the forfeiture of the gratuity? They will asking you. Time limits used in Payment of Gratuity Act 1972 they are asking. PF, what are the offences? RTP question. Interest rate, whatever they wanted to give, should not exceed the lending rate of the scheduled bank. Again, they are asking this in the case law. RTP question. Cover. Bonus. For calculation of bonus, what is the salary and wages computation? For what and all bonus will be applicable? For what and all it is not applicable? Again, they are asking this in your Payment of Bonus Act 1965. This and all is case-based question for both old syllabus and new syllabus. For new syllabus, IOS and GCA is extra. Now, for the old syllabus, ethics and communication, I have prepared the expected questions. I have prepared mnemonics. Some 56 questions if you study, ethics will get over. For 50 questions if you study, communication will get over. Already we have prepared that. So you can come back to us. You can either contact Hari sir or you can contact me. We will be able to provide you in the WhatsApp. We will also put that in the comment section, so you can accordingly take it from there, or we can also cover it from any other angle. Okay. So what are the theory questions that they are asking? Annual return. What are the particulars? 10 points is there. Annual return they are asking. Exceptions to indoor management and applicability to doctrine of constructive notice. Again, they are asking what are the exceptions to indoor management. There are 3 points. Knowledge of irregularity, forgery and negligence. They'll ask this. Payment of underwriters commission, security, shares and debentures. Theory question. Certificate by auditor. Should you give any certificate? What are the 5 conditions you should give when you are saying okay for an auditor? Contents of DRS 134. Conditions for issue of equity shares with differential right. I am marking it in green, yellow color because it's a amendment. It is no more 26% of the total issue paid up capital. It is 74% of the voting power. So they have used that, not 26 but 74. But it should not exceed 74. So accordingly, you can try to remember that. Eligible company in deposits they'll ask. Why creation of charge is necessary? They are asking this question. Issue of bonus share. It can be by way of free reserves or securities premium or CRR account. Again, that question they are asking. Transfer of profit to reserves is mandatory? No, not mandatory as per the dividend. How many types of prospectus? 4. Shelf, abridged, red herring, and offer of sale of securities, which is called deemed prospectus. Special notice? Yes, 1% of 5 lakhs worth of shares. Private placement? Yes. For whom it is to be given? Whether it is only for private but also for public? Yes, it is for both. So for both private and public. What is the difference between ordinary resolution and special resolution? There are 5 characteristics of special resolution. They will ask this in the examination. These are the points that are very important. Listen to this again and again. Will it be shared with us on the Telegram? Yes, we can also share. It's not a big deal at all. You can listen to this video again and again and again. Get the grip. Whenever you wanted to study the expected questions on this, you will be able to clarify on this. Sir, please clarify the exam dates change in yesterday's announcement. It's not for all. It's only for the people who are having an election in that state, and very clearly they will tell what are the containment zone, who and all is going to be covered, who will not be covered, what are the protective, everything will cover Swapna. So they are not telling everything clearly right now, but as of now think that there is going to be examination. So accordingly you do. Don't bother whether there is exam or not. Start concentrating for the exams. If it is there, suddenly you will not be able to prepare. You should start preparing now itself. So stop thinking about whether they will postpone further or not. It has got no connection with us. Let ICA take the decision. We will only abide with whatever they wanted to. Health is important, we know that, but they will accordingly take it. If we wanted to opt out also, there will be provisions, they will give it to you. So let's see how far it goes. Okay, now coming back, I wanted to keep it very intact within 45 minutes because the MCQ question, I'm going to cover it separately. I have covered only case law questions and the theory questions. You know which syllabus you are in, old or new syllabus. So listen to this video again and again. So you will be able to get all the points, whatever you wanted to write it and keep, or I can also ask through the Telegram channel. I can also share. I will also request Hari sir to do. We can accordingly manage it and make ourselves really, really strong. Okay, so this is what is for your last minute revision for law. When you are strong before the examination itself for the law, I bet you will be able to get an exemption very easily, because all these points are tricky points. So prepare confusing questions, prepare tricky questions, and prepare easy questions. So you know what is going to be done before the exam, what is to be done on the day of exam, what is going to be done on the day where they are going to give you a leave, 1 day full leave. So you can accordingly plan it. So thank you, Hari sir, for all the efforts that you have been taking it for the students. We are very, very happy to be a part of it, sir. So 45 minutes, I wanted to cover almost the last provision, and we have completed it quite decently.
Thank you, Bharath. Thank you so much. Dear students, tomorrow also we are having program 5 o'clock to 5:45. Intermediate as well as IPCC expected question, last minute revision strategy for costing paper. Kindly inform to share to your friends also. Thank you all of you. Thank you, Bharath Kumar.
Thank you, sir. Thank you, sir.
Bye. All the best for the exam, students.